Good morning and welcome to the third of our weekly Meet the Experts Q&A sessions with Sintons Employment Team. My name is David Pritchard and I'm the Head of Marketing here at Sintons. I know this is the third time of me saying this, but once again, can we thank so many people for having signed up to view the sessions today, and also the amount of questions we've had this week has again been phenomenal. It's our highest week of questions from you, so thank you once again. Very quickly from me, and just for the benefit of those people that are joining us for the first time, these sessions have come about due to the employment team here at Sintons having been inundated with COVID-19 and furlough related questions following the introduction of the coronavirus job retention scheme and the ever-changing government guidance. The team has also been giving some thought as to what work may look like following the relaxation of the current restrictions. So just moving the slide on. So as with previous sessions, it's going to be three questions that the team are going to take turn to answer. Our speakers today are Head of Employment Keith Land and welcoming Associate Catherine Hope. It's her first time of speaking in the Q&A sessions today, and me just introducing. So without any further ado, I'm going to pass you straight over to Catherine for question 1 of 3. Catherine, good morning and over to you.
Good morning, thanks David, and good morning to everyone. Thanks for joining us today. I'm going to kick off by looking at the area of bringing employees back to the workplace. Now, there were a couple of questions that really dealt with the same issues on this topic, and I'll deal with those together. First situation is you've got someone who's on furlough leave, they're office-based worker, they can work from home, you want to bring them back to work, you've got work for them to do. Your concern is that you think they'll be more productive in the office rather than when they're working at home. Can you require them to come in? Now, you need to think in this context, you need to think about your duty of care in terms of health and safety. Now, in that respect, there's the common law duty, and that's the duty to take reasonable care of those who your business operations will reasonably affect. You've got the statutory duty, of which there are many, but the central one is the Health and Safety at Work Act, 1974. There's the duty to ensure, so far as is reasonable practicable, to consider the health, safety and welfare of your employees. Now, alongside those, you need to think about then the government guidance that was published this week. So we had that came out on Monday night, the 11th of May. That's looking at working safely in the workplace with COVID-19. And there are 8 different versions of that looking at the different sectors, one of which is office and contact centres. Now, what really comes out from that, and a steady stream in terms of the statements, is the expectation that employees will be working from home if they can do, and it's only if they can't work from home that they should be required to attend the workplace. And there is a clear statement in that, and it states this in the guidance, that employers should be making every reasonable effort to, as a first option for their employees to be working from home. Now, it's important to note it's not the law, and it doesn't supersede those duties of care, but what I would say is it does provide good evidence of safe system of work. It gives examples of what would be reasonably practicable in the context of COVID-19. And what I would say and what I take from that is, in terms of complying with your health and safety obligations, as a minimum, there is an expectation that you will at least take those steps to enable your employees to work from home if your business can function properly with them doing so. Now, I know that question of whether your business can function properly is an interesting one, because many of the businesses and organisations where employees are working from home at present, yes, they're working from home, but are they functioning properly? Probably not. They're managing in the current situation, and how sustainable that is going to be and for how long is another discussion entirely. What I would say in this context is you need to think about what work is there for that employee to do and what can they do? What will the difference be if they're actually in the office? Because a number of duties that someone might not be able to do are going to be affected by the current restrictions that continue to be in place, such as our ability to get out and about. Taking aside any issue of any increased risk due to someone's personal health circumstances, in this situation, my view would be that you have to at least give it a go, especially if someone's been on furlough leave and they haven't been working from home. You need to be showing that you're making that reasonable effort. Remember, that's a big statement from the guidance. Home working isn't easy. It's something we've all had to get used to. I mean, from my own perspective, I'm living with a potty training 2-year-old, so there's a lot to get used to in that respect. But I do think you need to show that you've taken those reasonable steps. If there are real productivity issues, then yes, it may well be that that employee just can't work from home. But at least then you'll have something tangible to discuss with them when you're talking about requiring them to come into the workplace. So if it's the case that there are issues, my advice would be you need to really show that you've given that consideration. You've got that evidence to show you've taken those reasonable steps. It's not black and white, but that would be my advice. So that was one situation. Another thing that came up was in terms of apprentices and that need for their supervision. You want to bring them back into the workplace on the basis that they can't work from home because they need that supervision. Now, it's useful to know there has been separate guidance published by the government in terms of apprenticeships for employers and training providers and apprentices. That was last updated on the 24th of April, so do bear that in mind. Now, in terms of, there's not any specific guidance in relation to supervision, but what I would say is when the guidance talks about those apprentices who will be required to come into the workplace, in the guidance at the moment, it does talk about those critical workers, so those involved in the critical response to COVID-19. Obviously, things have changed this week with those who can't work from home. We're looking at the clear examples of those in the construction and manufacturing industries. There is a lot of talk in that guidance about flexibilities and allowing apprenticeships to work from home. And one thing I would take note of is they do give examples of apprentices working from home. And from that, I would take that the clear position that all apprentices need supervision, which of course they do, isn't a direct barrier for them working from home. That being said, we do know that is extremely important. And I think it's going to come back to that main question. Can the apprentices, can they do their job from home? And that's what you need to look at. What work are you going to be asking them to do when you bring them back from furlough? How are they supervised? Can that be done differently? What is it about the supervision that needs to be done face to face? You need to show consideration of those points and consider that in that regard. What I would say is the government has said that the guidance in terms of apprentices will be updated on the 1st of June. So do look out for that being amended in the next couple of weeks, because that may, by all means, bring some further guidance. Just on a final point, something that was raised in relation to bringing employees back to work about that refusal, and I'll just finish on that point. In a different situation, if someone can't work from home, but they're refusing to come in, you need to think about the Public Health England advice at the moment and the specific reasons why they're concerned and not wanting to attend. You need to obviously be looking at whether they fall into that extremely vulnerable group or the clinically vulnerable group set by the government, but also if they're saying they're disabled under the Equality Act and they think they're at increased risk on that basis. If there's no increased risk and they can't work from home, then the Public Health England advises that it is, it's reasonable for you to require them to attend the workplace. In that situation, you should be able to look at investigating the failure to follow a reasonable management instruction and unauthorised absence and dealing with that. There is a but there, and it is a big but. So do be mindful if that situation comes up, you need to carefully consider the reasons why they're concerned about coming into the workplace. Listen to what they've got to say. It may well be they have concerns about colleagues who are not following the safety procedures that you've put in place. They may have concerns that could be easily resolved. And it's really important to note that if you're raising concerns about health and safety in the workplace, that could amount to a protected disclosure under the whistleblowing legislation and all of the protection that brings with it. Also, just on a final note, the guidance that was updated this week on the government website, there's a frequently asked questions section of that, and there is a point when it's talking about concerns about coming back to work. There's an expectation that employers and employees will have good discussions about those and hopefully come to pragmatic agreements. So that's a quick overview of those particular issues that were raised. So I'll pass you over to Keith to see if he's got anything to add.
Thanks, Catherine. I don't really have masses to add, and thankfully there's the telephone ringing just at the wrong time. If everyone can hear that, I do apologise, but I can't help it. It's undoubtedly at this time my mum ringing. Anyway, coming back to the point, I think Catherine covered everything and covered it in a very full way. What I would say, it is interesting just talking to clients that a lot are already looking at, even with office-based people, of getting some of their people back into the workplace, largely because a lot of people are finding it pretty stressful being sat at home, detached from the business, not knowing what's going on and things like that. And so one massive employer that I was chatting with has decided, for health and safety reasons of its workforce, that they need to open up their office space again. Again, I'm not cutting across what Catherine said. She's right. You've got to look at can people work from home, and a lot of them do, because it's an employer that has a main hub in the Midlands, but thousands of employees dotted around the UK, and they don't really have offices outside the Midlands. So lots of people working at home anyway, but they are opening up their workspace to try and get people into the workspace because of the affinity they have with the office, which I think is an important consideration for moving forward as well. Okay, moving on, just before I get on to the second question, I should add, just to echo Catherine's comments in relation to being at home with a 2-year-old. Just as I was speaking last week, my daughter decided to put on Grease, and all I could hear was blasting in my right ear hole was, tell me more, tell me more. Oh well, oh well, oh well, ooh. So there you go. I took it as somebody wanting to spur me on and tell them more about the law. So that's what I'm going to do. Anyway, my question is touching on collective consultation and getting people back, and what the workplace is going to look like afterwards, and if you have to make redundancies, and in this particular case, a mass redundancy. In a sense, it's what's an establishment for collective consultation. The question said, well, we have one company with a head office, several branches, central accounts team, senior management. Each branch has its own employees and they only work at those branches. For those of you know, a mass redundancy is where an employer is making 20 or more redundancies at one establishment in 90 days or less. And it touches on this question of one establishment, because you've got one company and several different business units. Obviously, in this case, one head office and several branches. Can they be treated as separate establishments for the question of mass redundancies, and therefore the 20 employee threshold has to be hit at each individual branch rather than the company as a whole? Before getting to that question, the question sort of hits on one major point of one company. So do you have to aggregate establishments across group companies? Well, the short answer to that is no, because the legislation says an employer that is making 20 or more redundancies at one establishment. And therefore, if you have various group companies that are different legal entities, they are different employers, and therefore you wouldn't have to aggregate the numbers across group companies. Nonetheless, just to confuse matters, if you go through a redundancy exercise and you get round to considering alternative employment, you do have to look at alternative employment across every group company in order to make a redundancy dismissal fair. Anyway, I've digressed already. What is an establishment? Well, look, it's one of those happy employment law questions where every case is fact specific. There are some tests, and it's one of those cases where, surprisingly enough, the UK is at odds with the European directive, or the UK position is at odds with the European directive, and you're probably all sat there going, oh, here we go again, European cases making life in the UK more difficult. However, funnily enough, this is one of those areas where the European decisions have made life in the UK a bit easier. Which they are few and far between. What in effect you have is a couple of, you have a Danish case, Rockfon, and another one which I'm going to try and pronounce, but I'm not going to make a very good job of it, called Ath Inaiki, from 96 and 2007 respectively, where they looked at what's an establishment for the purposes of triggering mass redundancy legislation. And they said that the question should be interpreted very broadly, so it should be looked at from the perspective of the employees, and to ensure that the legislation bites as much as possible. So in answer to your question, that's the first point you got to bear in mind, that the courts and the tribunals will look at this legislation, and if there's a chance that it should bite, they will have it biting. However, it's said an establishment is a distinct entity that has a certain degree of permanence, has assigned to it performance of certain tasks and has its own workforce and organizational structure to perform those tasks. So in a sense, if you look immediately at branches, you might then say, well, okay, separate branches are potentially separate establishments, and so if I don't trigger the 20-person threshold at each one, no mass redundancy legislation. The cases went on and said it doesn't have to have legal, economic or financial autonomy. So you can have a head office and then a branch structure. It doesn't have to have its own separate management who carry out those redundancies. And so somebody from head office can come in to carry out the redundancies. There does need to be a question of geographical separation, which is a really important factor. What you then got is you had that Danish case, and I presume it's a Greek case, I can't recall. And then you had the Woolworths case here in the UK, where Woolworths went into administration, and it said, well, actually, separate. We have lots of different shops. Lots of them don't have 20 employees, therefore they are all separate establishments. And they put those arguments in front of the ECJ. Well, they put them in front of the UK courts, and the UK courts actually referred them to the ECJ, is what I should say. And they came down in favour of Woolworths, and they said, well, no, that the ECJ guidance is that they should be separate establishments. Now, the reason for that is because of differences in how the directive is structured. When the directive was produced in Europe, member states had a choice. They could choose a percentage threshold. Okay, so 10% of the workforce at an establishment is being made redundant, it triggers, and therefore if you've got 10 employees and one is to be made redundant, you trigger the mass redundancy legislation. The other option is you go on a number of employees at an establishment, which is what the UK chose. The UK is in a different position to the majority of Europe in this respect, and therefore the directive has to be applied in the terms to make the directive kick in, and therefore the mass redundancy legislation kick in as often as possible. And therefore you had these two different principles that work at odds with one another, if you see what I mean. The European courts wanted to drive the percentage down to the smallest number, and when you do that, applying it to the UK law, it means that actually you treat things as separate entities. So the European decision wanted to say, well, actually these are all separate entities, all the branches, and therefore if you've got 10 employees, you make one redundant, the mass redundancy legislation kicks in. But when you apply the UK model of 20 or more employees at one establishment, all of a sudden that fragments the whole process. And therefore the current guidance is that, given the Woolworths case, that the fragmented approach in the UK is the correct approach. And so, answering your question, yes, you could potentially treat them as separate establishments. However, you've got to look at the management structures to do that. They need to have day-to-day operational management at each branch. Shared support functions is not fatal, but you've got to have an argument of complete separation of each of those branches, and that won't be helped if customers cross branches, if employees cross branches and some work at one and then some work at another branch. Really, you've got to look at your working practices and make sure that those things really are separate, because what you actually have is you have an inconsistent position with the UK and the European law, and as a consequence, another court or another case could go a different way, and there is still scope within the directive for a different decision to be found, because they are fact and case specific. And so a court in the UK could say, well, actually, I know we've got the case of Woolworths, but in this instance, that there wasn't a specific degree of separation or sufficient degree of separation, so we're going to treat them as one establishment. Given that, a better way forward, if it's borderline, would be to treat them as one establishment, which I know gives you a bit of a longer consultation period, but you can then probably better carve up your selection pools to separate establishments on a geographical, carve up your selection pools better on geographical locations, because an employer has a great deal more flexibility in setting its own selection pools, so long as it applies its mind to a question and comes out with a reasoned answer. So long as it's sensible, employment tribunals can't interfere with it. That was my rundown on establishment. It's a massive question and I could waffle on forever, but Catherine, I don't know if you have any thoughts before you move on.
No, I mean, that was a really good summary, Keith. It's an important point to establish, no pun intended, more so because it determines whether the duty to inform and consult is engaged, and we all know that obviously failure to follow that does have substantial consequences. So useful information there. I'll use that time to move on to the final question. It's dealing with sick leave and pay and delayed medical procedures. The question came in here was with regards to a situation where you've got someone on sick leave, they're due to have an operation. In light of the pandemic, it's been postponed with no idea at the moment about when the NHS will be in a position to reschedule that. The question came up as to if they're in a situation where they've exhausted their contractual and statutory sick pay entitlement, is there an obligation on the employer to extend that and continue to pay them and also to keep them employed? So there's 2 points here. Starting with pay, in terms of the contractual side of things, you need to always look at the contract and the contractual terms. Unless there's anything in there that allows the wording to be interpreted in such a way that it would cover this kind of situation, then there won't be an obligation for the entitlement to go beyond, the maximum that they're entitled to. So no, there's not then a consequent, the consequence there isn't that there was an obligation to increase that. What I would say, it's in that situation, it's for the employer to decide. It's entirely up to them whether they decide to pay a bit more in this situation, but that's a decision for them. In terms of statutory sick pay, again, if they've exhausted their entitlement, so it's the 28 weeks, there won't be an obligation to extend that. We know that there were some changes to the statutory sick pay legislation back in the middle of March, and that was about who will be covered by, in terms of what the meaning of incapacity and covering those who have got COVID-19 symptoms and those who are self-isolating. There was no change there in terms of the actual time period of entitlement, the 28 weeks. So again, there's no obligation. If they've exhausted that, that's it. In terms of keeping them employed, employment here, it's going to be the situation as in any other kind of situation. It's about following a fair procedure. And many employers will have a sickness absence procedure in place that deals with long-term absence. In this kind of situation, it's not the question as to whether if the operation's postponed, can we move to terminate their employment? It comes down to that question of, are they capable of doing their job, or are they going to be? Now, in terms of the postponement of the operation, if it was the case that if they'd had that as scheduled and they would have been back to work quite promptly, their extension of their absence is an indirect consequence of the pandemic, and it might, if you've got a procedure that has particular trigger points, it might well then trigger a formal action in that regard. And from the employer's perspective, you've got two options really. If you're in a position where, given there's no obligation to pay the employee anything, and you're able to resource-wise to manage that continued absence, simply leave things how they are and see when that operation can be rescheduled, and keep in touch and see how they're doing in terms of getting them back to work. Fully appreciate though, in a different situation, an employer simply might not be able to sustain that, and they might need to have that role fulfilled in terms of their resource needs and things like that. In that situation, it's like it would be in a different situation. You'd need to then instigate your formal sickness absence procedure, and it's all about then having those formal meetings with an employee, consulting with them, considering whether their condition amounts to a disability and all the duties and obligations that go with that, and looking at that medical opinion. So there's nothing really different in that regard in terms of dealing with long-term sickness absence and the question as to whether someone is capable of carrying out their role. That's a quick overview of that question. I'll just pass you over to Keith to give a final comment.
I didn't have anything else on there, to be perfectly honest with you. Catherine, as ever, you do a really full overview of everything, which is why we have you around in the office in the first place. So thanks for that. The only other thing I would say, which harks back to my question, is if you haven't already seen it, we are doing a full session on Thursday next week on the return to work collective consultation, what the world of work will look like as we continue to transition back to the workplace. And so more details on the kind of things that we've been talking about today are to come next week. And so to wrap up, I'll pass you back to David, and thanks everyone for tuning in.
Thanks, Keith and Catherine. As I mentioned in the previous sessions, we're working hard to produce and deliver useful and relevant content at the moment, articles, blogs, podcasts and videos, all of which can be found on our website at www.sintons.co.uk should you wish to take a look. And this includes the first 2 episodes of this Q&A session. You can also follow the employment team on Twitter at Sintons HR. If you'd like to discuss anything the team have raised today further, I'll move the slide on quickly. Their contact details are on the screen. Also, if there's any other type of employment inquiry, other type of legal inquiry, please don't hesitate to get in touch. As I mentioned, we're bringing these sessions to you each Friday until the end of May, and I'll pop the link round for the next session after the weekend. So all that's left for me to say is, from John Travolta, Catherine Hope and myself, thank you very much for listening this morning, and we look forward to speaking to you again next week. Stay safe, everyone. Thank you.